You know, you pay your HOA dues every single month, but do you really have any idea where that money is going? Well, when one homeowner tried to find out, her association basically said, nope, you can't see the records. And that refusal, it sparked this huge legal battle over a really fundamental question. How much financial transparency are you actually entitled to? We're going to break down this whole case right now.
So, on one side, we've got Roberta J. Stevenson-McDermott, a homeowner in this community for 30 years. And on the other side, the Palms Homeowners Association, which runs the 74-unit condo complex. Their little disagreement over getting access to financial records just kept getting bigger and bigger until it turned into a formal legal petition.
Here's how we're going to walk through this. First, we'll look at how this whole dispute got started. Then, we'll dive into the exact record she was fighting for. We'll also hear the board side of the story, and then, of course, get to the judge's final decision. And most importantly, we're going to talk about what this whole thing means for you, whether you're living in an HOA or serving on one.
So you might be wondering, how did it even get to this point? I mean, a full-blown legal case? Well, this wasn't some sudden flare-up. The tension between Miss Stevenson-McDermott and her HOA had actually been building for years, and it was all rooted in what she felt was this major shift in how the association was being managed.
And you don't have to take my word for it. In her own statement at the hearing, the homeowner, Miss Stevenson-McDermott, pointed to a very specific moment in time, January 2016. She said that's when a new board came in, and suddenly, all the transparency just vanished. She argued that this legal fight was basically her last resort to just see where the money was going.
Okay, so what records are we talking about here? It's not like she was just asking for a single receipt. No, she was asking for years and years of detailed financial data that she absolutely believed was her right as a homeowner to see.
And I mean, just look at this list. It was extensive. It covered years of financial activity, everything from audits and budgets to bank statements and tax returns. Her argument was pretty straightforward. Without seeing these documents, how could she possibly know how the association was spending over $140,000 in dues every year? She just wanted to follow the money.
So what was the big red flag that started this whole deep dive? Well, during the hearing, Miss Stevenson-McDermott pointed to a key piece of evidence, a financial register from 2018. It actually showed payments being made directly from HOA funds to board members. And she argued this was all done without any kind of vote from the homeowners, which is exactly why she felt she needed to see everything else.
But of course, there are two sides to every story. The HOA had a totally different take on the situation. They claimed they were following the law, and that they had very good reasons for not just handing over copies of every single thing she asked for. Their entire defense was built on their reading of the state law and their duty to protect the privacy of other residents.
And this right here, this is the law the entire case hangs on. It's an Arizona statute that says an HOA has to make its records reasonably available for examination. But what does reasonably available actually mean? That little phrase, that's where this whole legal battle really takes place.
Now, according to the HOA treasurer, Mario Salinas, the board did make the records available. He testified in court that he offered Mrs. Stevenson-McDermott and some others the chance to come look at all the bank records in person, either at his house or at the local library. As far as the board was concerned, that offer was enough. They had done their part and fulfilled their legal duty.
So you can see how this boils down to a really fundamental disagreement. The petitioner, the homeowner, she argued that the law gave her the right to buy physical copies of the records so she could review them herself, on her own time. But the HOA, they argued that the law only required them to let her look at the records in person, with them there. Two completely different ways of interpreting the same exact law.
The HOA treasurer explained why they were so hesitant to just hand over copies. He said things like bank statements had other owners' names and payment info. He also said he was worried that if people found out who was behind on their dues, it could lead to harassment and fighting between neighbors. They genuinely believed the law was on their side and allowed them to hold back records with that kind of private financial information.
So, after years of this back and forth, all the arguments were finally made, all the evidence was on the table, and everything was left in the hands of an administrative law judge. It was up to him to look at the facts, look at the law, and make the final call. From a legal standpoint, the official process moved pretty fast, actually. The petition got filed in February, the hearing happened in June, and then just a couple of weeks later, on July 8th, 2022, the judge issued the final decision that would settle this whole thing once and for all. And the judge's order was, well, it was simple and direct. The homeowner's petition was denied. That's it. After all that time and effort, her case was completely unsuccessful.
So why, right? After all the arguments about transparency and a homeowner's right to know, why in the world did the judge side with the HOA? Well, the reason is incredibly specific, and it all comes down to a really crucial, kind of surprising, procedural detail. So here it is. The judge's entire decision basically came down to this one critical point. He found that even though Ms. Stevenson-McDermott had asked for the records verbally, she had never once submitted a formal request in writing, which is exactly what the law requires. So the case wasn't decided on these big ideas of privacy versus transparency. It was decided on a procedural mistake. She just hadn't followed the exact letter of the law.
So, what can we all learn from this? I think beyond this one specific fight, the judge's decision really gives us a clear roadmap and maybe a warning for both homeowners and for the people serving on HOA boards.
Okay, so what is the right way to do this? Well, that Arizona law is crystal clear on the process. Step 1, you have to submit your request, whether it's just to look at records or to get copies. It has to be in writing. Step 2, the HOA then has 10 business days to get you what you need. And step 3, if you ask for copies, they can charge you for it, but they can't charge more than 15 cents a page.
All right, let's just recap the big lessons from all this. First and foremost, procedure is everything. A verbal request just doesn't hold the same legal weight as a formal written one. Second, that phrase, reasonably available, can mean very different things to different people. Third, HOA boards do have legitimate privacy concerns they have to balance. And finally, remember, the burden of proof is always on the person filing the complaint to show that the law was actually broken.
Ultimately, this whole case leaves us with a really critical question, one that every HOA and homeowner has to think about. It's a tough balancing act, right? At what point does protecting the privacy of some members start to become a barrier to the transparency that all members deserve? It's something to think about.